Allen, deceased, et al. Versus Benjamin Dehner, MD, et al.
Good morning, Mr. Caparella.
Good morning. Thank you for your patience, Your Honor.
Sure.
You came back much quicker than we anticipated.
I assumed we would surprise y'all.
My name is Donald Caparella of the National Bar, along with Tyler Yarborough and Bruce Smith, a member of the Memphis Bar.
Hello.
We represent Stephanie Allen in this case. I'd like to reserve 3 minutes for rebuttal.
3 minutes, yes, sir.
This case arises from a medical malpractice case that was filed by Donald Allen, as well as his wife Stephanie Allen, against the defendants. And the complaint had a proper certificate of good faith attached, but unfortunately 10 months into the lawsuit, Mr. Allen passed away. First amended complaint was filed by agreed consent order that essentially repeated exactly the allegations of negligence. Nothing changed except for the wife was substituted as the plaintiff. She was already a plaintiff as a spouse, but she was substituted as plaintiff under the wrongful death statutes. And then the allegation, of course, was made that Mr. Allen died. Then 11 months of discovery happened, and opposing counsel filed a motion to dismiss that was granted by the trial court, which is why we're here on a motion for dismiss. And, Your Honor, this case raises a matter of first impression. And here's the issue. Whether or not a new certificate of good faith is required when the same theory of liability is alleged, predicated on the same facts, covered by the original certificate of good faith, filed with the original complaint, especially when the First Amendment complaint incorporates everything in the original complaint, including the original certificate of good faith. Now, we have cases that highlight that this is a case of first impression. We have the Groves and Serball case, which says that when you add a new party with new facts about what the new parties did in a medical malpractice case, new allegations of medical malpractice, the Groves and Serball case, you have to file a new certificate of good faith. If you have an entirely new claim, like in the estate of Vickers case, in that case it was an informed consent claim that again alleges new facts, then you have to file a new certificate of good faith. But none of those cases are this case, where you have a First Amendment complaint that incorporates the original complaint, doesn't state any new facts, predicated on the same facts, covered by original certificate of faith, and filed with the original complaint. And what's interesting about this is the original complaint incorporated the certificate of good faith, and then the First Amendment complaint incorporated the original complaint, and therefore also incorporated the original certificate of faith.
But wrongful death was added, correct?
A wrongful death claim was added because a deceased person can't pursue a claim by themselves.
That's right. So with that new claim, isn't there another piece that has to be certified? I'm thinking that you didn't have to prove that the injuries caused his death before, because he hadn't died.
Correct.
So that's something new that has to be proved. And would the certificate of good faith be needed to cover that?
Well, that's the case of first impression that's here, and the answer we submit is no, and here's why the answer is no. The certificate of good faith statute specifically says that you need a certificate of good faith that says you've consulted a doctor who has looked at it and said there's a good faith belief to support this action. That's all it says. Now, it's true that the good faith statute incorporates 29-26-115, which lists the basic elements that you have to have for a medical malpractice case. And the third element says that you have to have to prove your medical malpractice case. This is not related to the certificate of good faith, but to prove your medical malpractice case, you have to have recognized standard of care has to be established, the defendant acted with less than standard of care, and then lastly, as a proximate result of the defendant's negligence, act, or omission, the plaintiff suffered injuries which would not have otherwise occurred. And at the time the certificate of good faith was filed, there were injuries. The person was suffering from cancer that had been misdiagnosed. And in the complaint, it alleged all the normal categories of injuries: pain and suffering, loss of enjoyment of life, disfigurement, all those things were alleged. So the Beard case, the Tennessee Supreme Court case, says that even though we have a hybrid wrongful death statute, that's part wrongful death and part survival statute, says, this is the Beard case, for this reason we have consistently noted that, like true survival statutes, they do not create a new cause of action in the beneficiary. So a wrongful death case is not a new cause of action. It's the cause of action that the deceased would have had they survived. So the very fact that it's just a new wrongful death case doesn't require a certificate of good faith when the First Amendment complaint doesn't allege any new facts. There's no, other than the fact that they had died, which they have to do because our law doesn't allow under the wrongful death statute for the plaintiff to pursue it.
So you just expanded the list of injuries to include death.
Right.
That's what you argue has happened.
It's a new injury. But the certificate of good faith doesn't say that you have to have a certificate of good faith that says there's a good faith basis that alleges all the injuries. It says that just a certificate of good faith that, this lawsuit has been filed in good faith to file this action.
And by stating that, what is it exactly that and we have a lot of certificates of good faith in Tennessee, what exactly is being attested to when somebody submits a certificate of good faith? What is it that the expert is saying?
That they have reviewed all the medical records and the allegations, and that expert, the lawyer saying that expert has found that there's a good faith basis to pursue this action, and the action didn't change just because the person died.
But doesn't that necessitate proof that the acts or omissions of the physician not only caused the injuries that the original plaintiff sustained during life, but additionally led to the death of that patient?
It does, but not at the pleading stage and not at the certificate of good faith stage, because the certificate of good faith statute just says good faith to file this action. It does rope in 2926-115, but all you have to do to state a claim is to say that as a proximate result, the defendant's negligent act or omission, the plaintiff suffered injuries, not all the injuries that they may suffer. So the certificate of good faith doesn't have to say anything about injuries. It just says actions. Now, lots of times when you have a medical malpractice case, the actual injuries you prove at trial may be different than what you started out with. Sometimes they can get maybe a spinal fusion that they weren't expected, but you wouldn't need a new certificate of good faith if they had a spinal fusion after a surgery. You wouldn't need a certificate of good faith if they got an infection from it, unless there was additional medical care that you wanted to prove. Here, the allegations in the First Amendment complaint are 100% exactly the same, except for it joins a new party plaintiff, not somebody that got medical care, but just the party plaintiff, the spouse moved over from being just a spouse to being a wrongful death person.
Counsel, under
Yes.
your understanding of a certificate of good faith then, could you appropriately submit a certificate of good faith with a claim where there's, let's say, a very minor injury that's
Yes.
supported based upon negligence, where you have a complaint that asserts some sort of much more substantial, much more egregious action, much greater harm than what's actually supported as an expert? I'm looking at this and there's this minor injury where, yeah, there's negligence, but the complaint itself goes way beyond that minor injury that's actually supported.
What I think your question is getting at, Your Honor, is the whole idea of a certificate of faith is to vet a lawsuit, so that way frivolous lawsuits are being, not filed. Here, though, we have a misdiagnosis of prostate and bone cancer, which very foreseeably can lead to death. So here, the fact that this person died was not an unforeseeable result. So this case didn't expand from a minor injury to a big injury. Well, if you have a wrongful death case, if somebody dies during the pendency of the lawsuit, and that causes more medical care by these, if you could say that these defendants caused that subsequent death, so there was more medical records that they had to go find of their own actions, then maybe you would need a new certificate of good faith. But here, the actions they're going to be judged upon based upon the first complaint and the First Amendment complaint are exactly the same. There are no new medical facts that they need to know about, except for the fact that this person has now died. That's just another injury. And if you were to rule...
But counsel, I mean, the cause of death could be something other than the misdiagnosis. I mean, and you could have some other cause, whether it's medical or otherwise, that leads to the person's death. And doesn't an expert need to assess that and say, yeah, there's a certificate, here's a certificate of good faith, there's a good faith basis for believing that is as a result of this negligence?
I would submit that would be expanding the language of the Healthcare Liability Act, which just says there's a good faith basis to bring this action. We know under wrongful death law, the action doesn't change. Under the Beard case, it's still the same action. So you would be reading, and all they need to do is that they suffered injuries. But if you add that level, you have to anticipate that the person will die or get a new certificate of good faith after they die. But no facts are being changed. I mean, after all, if they'd done, let's say they'd given this doctor, the fact that he died. The certificate of good faith, which is done by the lawyer, by the way, not the doctor, would have said exactly the same thing, that there's a good faith basis to file this action. It wouldn't have said to file this action because you caused his death. The certificate of good faith would have said exactly the same thing. So they wouldn't have learned anything from a new certificate of faith, and the whole vetting and notice process wouldn't have been changed one iota. So the statute just says plaintiff has suffered injuries based approximately caused by this. So this is a case of first impression, and I think you can use the fact that this case is not like the Beard case, or it's not like the Beard or these other Serball and whatever cases. It's not like those. It's this complaint essentially didn't change. So that's my argument, and thank you.
Thank you, Mr. Caparella. Mr. Mays, good morning.
Good morning, Your Honors. Taylor Mays and Jim Beeks of the Nashville Bar. We're here on behalf of Dr. Benjamin Dehner and Associated Urologists of Nashville. We respectfully submit on behalf of those parties that Judge Brothers and the trial court correctly found that when the plaintiff went about to amend the complaint in this case and to change out the names of the parties, assert new facts, Mr. Allen's death is a new fact. That was not something that had occurred by the time the original complaint was filed. Clearly, it's a new allegation to say that this man's death was caused by the alleged negligence of Dr. Dehner. And
Counsel, with regard to the other claims, is there any change here?
as far as the other claims, I would submit that the amended complaint changed a couple of things. It certainly changed the caption of the case. All of a sudden, Ms. Allen is proceeding on behalf of all the wrongful death beneficiaries of her husband's life. Certainly, the addition of the wrongful death claim changes things.
Does it change anything in terms of what's being attested to by the certificate of good faith?
Yeah, it definitely does.
Well, what does it change in that regard?
Like you mentioned a few minutes ago, Mr. Allen could have died from other causes.
No, not the wrongful death, the other claims here. Is anything being changed with regard to the other claims in this case? Is there anything that's actually changed as a result here that is related to the attestation that's being made with the certificate of good faith?
The most significant change would be that the First Amendment complaint wasn't accompanied by a certificate of good faith, which we submit. The statutory provision requires strict compliance that it be accompanied by such a certificate. So that's a significant change, and certainly the reason the court dismissed the case. As far as the facts relating to the treatment Mr. Allen received or didn't receive, you know, the underlying facts remain the same, with the exception of, you know, the theory a year later after they filed their suit that this negligence led to his death. You mentioned there could be other causes of death. There could also be a situation, and we submit this case presents it, where Mr. Allen unfortunately had a super aggressive type of prostate cancer, and by the time he was seen by my client, that cancer was going to claim his life. And that wouldn't be due to any negligence or delay in diagnosis. That would just be a function of the fact that he had a severe aggressive type of cancer, which that's his injury, and certainly Dr. Dehner didn't cause him to have cancer. The question and the complicated medical issue that they do have to support with a certificate of good faith is whether or not any delay in diagnosis of his cancer caused his death, whether any earlier intervention of cancer treatments would have made a difference in his outcome. Those are significantly complicated medical issues that have to be reviewed and attested to by a qualified expert. What they seem to ignore in the certificate of good faith statute is that it doesn't just, reference the requirements of a healthcare liability action set forth in 2926.115. It says consistent with the requirements of 2926.115, which of course require proof of the standard of care, a deviation from that standard, causation, critically for our purposes here, and damages, also critically for our purposes here.
What is being attested to with a certificate of good faith? And what is it is it that every claim is valid? What's being attested to by that certificate of good faith?
In my mind, the certificate of good faith is a review by a qualified expert attesting that there's a good faith basis to maintain the action consistent with the requirements of 2926.115. This isn't a truck wreck case where somebody died and they later needed some kind of a spinal surgery. Sure, in that situation, if you've pled properly, you don't need to amend your complaint every time, additional treatment is required. But you also don't have to bring a truck wreck case consistent with the requirements of a specific statutory scheme that applies to healthcare liability actions like we have here. So you can't get around the requirements of 2926.115 when you choose to amend your complaint to convert it to a wrongful death case. You still have to comply with those requirements. We submit the estate of Vickers case is, it's not the exact issue, but it's pretty squarely on point. That's from this court. They tried to add an informed consent claim, and they threw out everything. They dismissed that entire complaint. They didn't.
Did Vickers reach a conclusion on the full complaint, or did Vickers or was that issue essentially pre-permitted in that case?
My reading of Vickers is that the only thing they didn't reach was the issue of whether the amended complaint constituted a comprehensive standalone document or an amendment to the previous complaint. They were able to avoid reaching that issue, which is discussed in some of the other case law. And it's important to look at this. I mean, they offer this language about incorporating and referring to the complaint. A fair reading of these complaints indicates that the amended complaint, when they went about preparing it, they started from the top. I mean, they changed the caption of the case, they changed the description of the parties. The first paragraph begins with jurisdiction, venue, identification of the parties, sets forth each cause of action. It has damages sections. And the preliminary statement before each section that says we hereby incorporate and reallege as if stated verbatim herein, that's something lawyers use a lot to refer to things in the same document. And the best evidence is that is if you look at the original complaint, where there was no previous complaint, it contains the same
But
one.
does this amended complaint expressly state that it supersedes and replaces the original complaint?
It does not expressly state that. I believe the case law says that what's required there is you analyze it. Number one, does it refer to or incorporate the previous complaint? They argue that it does based on the language I just discussed. But secondly, was it intended to be a comprehensive, all-encompassing, standalone document? As opposed to, for instance, if you want to amend, if you're a plaintiff and you want to amend your ad damnum to increase it, it's something you have to do or else you don't get anything over the amount. In that scenario, sure, you could file a motion to amend that is limited to changing the ad damnum that also then states and everything else in the original complaint is hereby incorporated and, you know, referenced and relied upon as if fully restated herein. In that situation, your amended complaint would be far shorter than your original complaint. Here, the amended complaint contains everything that's in the original complaint plus a critical issue of a claim for wrongful death. So
Putting aside the wrongful death claim, how is the purpose of requiring a certificate of good faith served by having that be a basis of dismissal with regard to the claims as to which there was a previous certificate of good faith? I mean, we know we know it meets the requirements for certificate of good faith with regard to the original complaint. It was filed. And how are we serving the underlying purpose of the statute by applying that requirement to the amended complaint with regard to those claims? I'm putting aside the wrongful death claim, but how is that purpose being served? I mean, have we already had an attestation that it's not a frivolous claim, that those requirements of the statute are met with regard to those specific claims?
I would say that the statutory scheme clearly requires strict compliance. The only exception for not filing a certificate of good faith is you have to demonstrate extraordinary cause. Now, these are not low legal burdens. These are high legal burdens. So I would say that's just the law. The appellate courts have had to revisit this statute a number of times, and, you know, depending on which side you're on, there's perceived unfairness in some of the outcomes for reasons, you know, that give rise to your question. But I would say that if you're a plaintiff and you and your husband file a medical malpractice action that is then litigated in discovery for almost a year, and then there is a death, and then there is it's a sea change of events to take the first complaint and then recast it as a wrongful death claim and cite all the new statutory provisions that come into play. You know, that action right there by statute requires a certificate of good faith to be filed, even if the certificate of good faith is going to essentially say everything the original certificate of good faith said, plus something to support the newly added claims. So I would say that that is simply the law. It requires strict construction, and there's been no extraordinary cause or excuse provided for why this wasn't done. There was no motion for additional time to go out and fix this. Instead, they responded to the motion to dismiss. Trial court considered it all and granted our motion to dismiss. We think that's proper. You know, a fair reading of this amended complaint can only lead to the conclusion that it is intended to be all-encompassing. It is intended to stand alone. It states within the body of the amended complaint that a certificate of good faith is attached to this complaint, filed simultaneously herewith this complaint. And it just didn't happen. There's no way it could. There's no way the original certificate of good faith could apply to the factual scenario that existed when the amended complaint was filed, because there had not been a death. So any attempt to rely on that can only get you so far, but doesn't get you to the death claim. So we submit, you know, as harsh as it may be, that not filing one was a
same
failure.
question I asked opposing counsel. Do you have a valid certificate of good faith? If we've got, let's say, a relatively small injury and negligence related to causing that small injury, but the complaint goes much beyond that in terms of the extent of the injury, the type of negligence, the extremeness of the medical malpractice involved. Do you have a valid certificate of good faith in that case if what we have filed, as the expert said, yeah, there's good faith for the action, or is that a misuse of a certificate of good faith in that case? And if it is a misuse, on what basis would we reach that conclusion?
I think my response to that would be the certificate of good faith statute requires more than some showing that a doctor looked at this and said, yeah, you got something there to go on. I mean, that's not. That ignores what's required to pursue claims against healthcare providers.
Are you attesting to all of the claims being asserted as being valid, though? Or are you just asserting that there is?
Yes, absolutely. Yes, I mean, in healthcare liability cases, most claims are kind of subsumed into the Healthcare Liability Act, so you're not dealing with, you know, a bunch of different claims. typically. So no, yes, that is what the language consistent with the requirements of 2926-115 means. And that statute's been around forever, for my purposes, as far as how you go about asserting healthcare liability claims, what you have to prove. And the certificate of faith encompasses all of those requirements, which include causation, which is critical when you start accusing people of wrongful death, midstream. So, I don't think it's an unfair outcome here. I think it was, error not to include a certificate of good faith with the amended complaint, and according to the statute, that warrants dismissal of the case.
I am wondering about Mr. Caparella said that this was just a new injury, not a new element which must be approved by the certificate of good faith. So, and they indeed added death to the list of injuries in the complaint. But your argument, I'm just trying to make sure I understand everything. Your argument is that it's a whole new statutory system. It's a whole different claim because it's wrongful death. It's not an adding of something, another permanent disability or something like that. Is that?
That's correct. We would cite to the estate of Vickers and the court's conclusion in that case where the court said, quote, by requiring a good faith basis to maintain the action consistent with the requirements of 2926-115, the language of 2926-122A, which is a certificate of good faith statute, implies, quote, that plaintiff has consulted with at least one qualified expert who reviewed the claims and believes the defendant deviated from the standard of care and that deviation approximately caused the plaintiff's injury. So again, I would point to the requirements of the healthcare liability statute as far as what a plaintiff must prove. That includes causation and damages, and certainly when you're going to convert a healthcare liability action into a wrongful death healthcare liability action, you can't rely upon things that were filed with the original complaint.
The quote you gave, it's the certificate of good faith to maintain the action. This action is a healthcare liability action. It just happens to also include the component of wrongful death to the extent that the claim is still that of the patient, now the deceased, but those who will receive the proceeds are his spouse and children.
Right.
Why does the action change?
Because of our statutory scheme that requires healthcare liability actions to be accompanied with a certificate of good faith indicating that an expert has reviewed the claims. And to add a new claim for wrongful death, I understand it's not a separate cause of action. It's wrongful death under the Healthcare Liability Act, which I think is why more is required in this case.
But doesn't the statute refer to maintain the action, not maintain the claim?
It says maintain the action consistent with the requirements of 2926-115, which very carefully goes through the elements of a healthcare liability action, which include, most importantly here, causation and damages. Okay. Thank you.
Thank you, Mr. Mays. Mr. Caparella, your rebuttal.
My opponent mentioned that she shouldn't read the First Amendment complaint as it actually reads on the page, but because he thinks it was just a cut and paste job, and the First Amendment, and as far as the incorporation language, but on a motion to dismiss, you have to take the language as you find it. You can't look behind it, and it specifically incorporates the complaint. And it's a First Amendment complaint, so that has to be a different document. And the First Amendment, and the original complaint incorporated the certificate of good faith. So we think the trial court also erred by finding that the First Amendment complaint completely replaced and extinguished the original complaint. So that's the second element. And I believe the trial court is wrong about that, and my opponent is wrong about that in saying that if you just look at the complaint and the First Amendment complaint, we know what really happened here, but you can't look behind that. And the last thing I want to say is in the estate of Vickers case, that involved a new cause of action for informed consent, which required the defendants to understand a different kind of, not even a different kind of negligence, but a different actual cause of action that changed the way they would look at defending a medical malpractice case, which you would need expert proof for. You would need an expert to testify about what the informed consent, whether there was a legitimate good faith basis to bring an informed consent claim. Here, as Your Honor said earlier, the action doesn't change. We know that both just from a common sense standpoint, but the Beard case makes it clear that when you file a wrongful death case, you're not filing a new action. So we submit that this is a case of first impression, and it raises a situation where when all you add to your complaint is a new plaintiff, which you're required to do for the wrongful death statute, although she was already a plaintiff as the spouse, and you say, we have this new injury, and the Health Care Liability Act says claims here and actions here, and doesn't say that they're the same thing, that if you have a good faith basis to maintain an action, if the action simply goes from a health care liability case to a health care liability case that caused a death, you haven't required a certificate of good faith. So we'd ask that this court revert. Yes, Your Honor.
When the certificate was being prepared, based on the complaint and all the medical records, was it foreseeable that Mr. Allen was going to die?
Well, it is reasonably foreseeable that a person who has cancer could die if it's not diagnosed in a reasonable amount of time. So that means the defendants would be on notice that that was a foreseeable injury that he would have.
Thank you.
Thank you.
Thank you, Mr. Caparella and Mr. Mace, for your arguments. We'll take your case under advisement. That concludes the morning docket.